Hi everybody, welcome back to the 10th of an hour. For today's episode, episode 54, we're going to go with a simplified subject, directed trusts. The overall theme here is that trusteeship has molded. You used to vest all functions of acting as a trustee in one individual or in one institution, but increasingly we've seen that these roles can be split out by specialty, by affinity, or even by the need to protect beneficiaries from themselves, and by the need to drive better trustee succession as well, and to induce people to actually serve as trustees. Now, as always, this presentation is not intended to substitute for legal or tax advice. So, trusteeship in general can often be viewed as three hats that a trustee might wear. The biggest would be distribution decisions, especially where discretion is granted to the trustee with respect to the income and or the principal of the trust, and how much or the size of distributions and the frequency of distributions and so on and so forth. And we'll touch on that here a little more in a bit. But administrative functions are also a driver. These would include things like legal decisions, accounting, inventory, tax returns, bookkeeping, minutes and resolutions, anything written down. And administrative functions tend to be the affinity that allows you to establish a trust's situs within a particular state. So if you wanted to take advantage of the laws of a state other than the state in which you live, the easiest way to do that is by delegating administrative functions to a trustee in that other state. Then finally, investment decisions are another piece that is traditionally delegated out, but the trustee at the end of the day is still on the hook for making sure that investments are prudent and reasonable, unless the prudent investor standard is waived or relaxed within the trust itself. Now, where trustees don't have knowledge of these items or have a knowledge gap, trustees are encouraged to farm out or delegate these functions, especially investment and legal decisions. That's how, as attorneys, we make our money in trust administration, is by advising trustees on some of the legal nuances of the administrative function, and even sometimes distribution decisions. However, the problem is that trustees remain on the hook for these decisions made under their watch. A trustee can delegate functions, but they still are liable, even though the delegation itself reduces the risk of liability. And thus, with that issue, directed trusts have become more accepted in different states and more in vogue. Now, what directed trusts really look at is the fact that functions can be delegated and farmed out, but now in a way that could limit the trustee's liability, because the trustee can delegate functions and take direction from the individual or entity making those outside decisions. So what that does is it results in a dynamic called a directed trustee, because the trustee is being directed, for example, with respect to investment functions, or maybe legal or administrative functions, or even distribution functions. And in most states, the trustee, when directed, can limit their liability except for bad faith or reckless disregard for the trust. So for all but the most just asleep at the wheel types of decisions or intentionally hurtful decisions, this allows a trustee to limit their liability. And this can help when it comes to the choice of trustee, because traditionally there's been a polarized decision as to whether you choose an individual or a bank or trust company as a corporate trustee, with really the difference being the fees, but also the difference being the willingness of that individual or entity to serve in a function where they may incur liability. So this helps to ease that and widen the realm of trustee choices, and trustee choice can be one of the most difficult aspects of getting a trust in place. Now, you can shift liability, as we noted, but the problem is here, the trustee, in limiting their liability, is now pushing that liability onto somebody like an investment manager. So that investment manager needs to be willing to take on that liability, which may be lower risk, but still there is a risk nonetheless. The question is whether that risk would be greater for an individual client versus a trust or vice versa. So in order to limit that somewhat, you can also look at this as bifurcating these roles into committees where action can be by the decision of maybe a majority of individuals, and this collaboration can protect the decision and also protect the liability of the committee itself. So there's a lot of larger trusts out there that'll split out into, say, a distribution committee or an administration committee and an investment committee and maybe even a competency committee with respect to the competency of a trustee or settlor or anything like that. Now, a beneficiary could also take on some of these roles, especially the direction of investments, which doesn't really cause a problem, and that could limit the liability of the trustee as well without affecting the asset protection or taxation of the trust. Because if you think about it, the beneficiary is the one who would be suing an investment manager if the wrong investments were chosen. So if you can delegate that function to the beneficiary, that essentially shifts the liability off the trustee's plate without making the beneficiary also incur liability because they're not going to sue themselves for poor investment decisions. But one point I want to make is that distribution decisions typically are not a good candidate for shifting to a beneficiary unless the discretionary distribution is limited by an ascertainable standard, such as health, education, maintenance, and support. Anything in excess of that ascertainable standard would create a general power of appointment when held by a beneficiary. Now, just notice an error in the slides. It says a general power of attorney. That should say general power of appointment, but I don't want to lay down this recording again just to correct that. But either way, if you have fully discretionary distribution standards, an independent trustee could be a good idea. And even with an ascertainable standard, in some circumstances and in some states, the independent trustee can help preserve more of the asset protection of the trust when it comes to distribution decisions. Now, you could give a beneficiary the power to distribute to others without liability by doing this in the form of a special power of appointment. Now, the benefit of a power of appointment is that it can be exercised in a non-fiduciary capacity, which relieves the beneficiary and trustee of some fiduciary liability. But the problem with this special power of appointment, especially if it's a lifetime one, is that in some circumstances that could be a gift from the beneficiary exercising that power to the other recipient or donee trust beneficiaries or parties. Now, some states have laws that now recognize the function of a trust advisor or trust protector, and depending on which state you're in, this role may or may not be recognized as a fiduciary role. If it is a fiduciary, then that advisor or protector is going to have potentially liability for their decisions, but if not, they may be relieved of that liability. So a good way to think of this that I like to explain to clients is that if a trustee is the CEO of a trust, then the trust advisor or trust protector would function like the board of directors of the trust. So in that capacity, what that trust advisor protector would do is perform functions that aren't traditionally preserved for a trustee under state law or otherwise. Things like the amendment of a trust to adapt to change laws or change circumstances of beneficiaries, or maybe the veto power over trustee decisions, and even the removal or replacement of trustee or committee members. And since there's a risk of fiduciary liability here as well, increasingly in a lot of states, committee decisions for the advisor or protector role can work well, to limit that liability. And in that capacity, where there's another committee on the trustee side, the trust protector could act as a tie-breaking vote for those types of committees. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.